Hi, I'm attorney Ummi. Welcome back to my channel. Today we're going to be talking about what you need to know about what's included in a comprehensive estate plan. I'll be breaking down all the documents that are included in a comprehensive estate plan, as well as something else that should be included in your comprehensive estate plan. If you stay with me until the end, you'll find out. And before we dive in, I wanted to just remind you real quick that the documents are just the byproducts of an estate planning process. Now, they're very important because they're legally binding and they will keep your loved ones out of court and out of conflict. With that being said, let's talk about the different documents. So when I talk about the documents in a comprehensive estate plan, I like to categorize them into a will-based plan and a trust-based plan. For a will-based plan, basically means that you don't have a trust. So it's the same thing, but the trust plan has a trust and the will plan does not have a trust. So when you have a will-based plan, a comprehensive plan, you will obviously have what? A will. And a will is that document that you file with court when a person passes away and they don't have a trust. So you'll have to file that with the court because it states who gets what part of your assets and exactly who you want to be the guardian for your minor children and who you want to be your representative, that is the person who would basically be distributing everything that you've left behind for your loved ones. All right, the next document in the list of a will-based plan would be the healthcare documents. The healthcare documents are a set of 3 documents. The first one is what we call the medical powers of attorney, and that document basically appoints a medical agent to be in charge of making medical decisions for you. And then the second document is called the HIPAA release. I'm sure if you've been to the hospital by now, you've heard of HIPAA. And HIPAA is a law that came in and made it difficult for anyone to have access to medical records unless they are authorized. So that HIPAA release allows your medical agent to be able to review your medical records to make decisions for you. And then the third document is called the Healthcare Directive or a living will. Now, I'm sure you've heard of this one too. And the living will basically states what you want to happen when you're on life support. So do you want to be taken off of life support immediately, after a day, 7 days, whatever you want to happen? That is the document that you use to list that out. The next document that I want to talk about in a will-based plan is the General Durable Power of Attorney. This document basically allows your agent to step into your shoes and act on your behalf. So that person can sign a check on your behalf. They can sign a lease on your behalf. So they can do anything you can basically do when you're not able to do it. The next document I want to talk about is a memorial instruction. Now, the memorial instruction allows you to dictate exactly what you want to happen when you pass away as far as your funeral goes. What kind of music you want to be played in your funeral, if you have any honorary status that you want to be recognized during your funeral. Everything to the T about how your funeral should be conducted. Moving on to a trust-based plan. As you have already probably guessed, a trust-based plan has all of the documents we have already talked about in a will-based plan. In addition, though, it has what's called the revocable living trust. The revocable living trust is a document that allows you to keep your loved ones out of court completely. So when you pass away and you have a revocable living trust, now if it is properly funded, and I know that sounds technical and I'm happy to explain that more. So let me know in the comments if you want to learn more about the trust and how it works. But basically, if it is properly funded, then it keeps your loved ones completely out of court and they don't have to go through the probate process. Again, if you want to learn about probate process, go ahead and watch my video where I talked about probate and let me know if you have any questions in the comment. Along with the trust comes what we call the ancillary documents. And these are documents that make sure that basically your trust works properly. So assignment of personal property, saying that all of your personal items like your purse, your shoes, all of that stuff go into your trust. And then it comes also with what we call the certificate of trust. And that's a document that you can use with financial institutions as a proof that you have a trust. That way you don't have to carry your bulky 80-page trust to the bank if you need something done. Now, all of these documents are pretty general documents that you can use about almost anywhere in the country because they're pretty generic. Now, you definitely want to make sure you have state-specific documents. And if you move to a new state, you're going to need a revision for on your estate plan. But moving on to the next set of documents that would be in your comprehensive estate plan will be what we call the state-specific documents. In Texas, we have what we call declaration of guardians for yourself and for your minor children. So that's something that's super state-specific. And in some cases, the courts or institutions would not accept documents unless they comply with the state-specific requirement. At my law firm, Law & Law Group, if you haven't checked it out, click the link in my bio and check out our website. At my law firm, we create a lot more than just these standard documents that are usually made by most attorneys. We go a step further to make sure that your children are protected and raised by the people you trust when you become incapacitated. The reason why we do that is because you could have a will, and now your will wouldn't be effective until you die. So if you're just incapacitated, at that point, you're going to need a legal document that allows people you trust to take care of your children. If you don't have that legal document, anyone can step in and decide to take care of your child, and it is completely up to a judge to make the last call. So you definitely want to make sure that you have those extra documents to fill in the gap that the will leaves behind. And these documents include medical powers of attorneys for your children. They include nomination of what we call a short-term guardian that would help to step in and take care of your children before the long-term guardian can step in, which is usually after you pass away. And then we also have an ID card that states that you are a parent and you have a minor child. And if anything happens to you, you want a certain person or certain people to be called to come and be in charge of your children rather than the authority basically calling CPS or putting them in foster care until they can find who should be in charge. Another thing that we do at my law firm is creating a comprehensive asset spreadsheet for your loved ones. The reason why we do that is because there is so much money in the departments of unclaimed property across the country. And most of this money ends up there because people pass away and their loved ones don't even know that they own certain accounts. But by having this very comprehensive asset spreadsheet included in your plan, your loved ones know exactly what you have and exactly how to find it. Now, I mentioned that there is one more thing that's not just a document that should be in your comprehensive estate plan that I provide all of my clients, and it's definitely not something that all attorneys do, but I focus on passing on more than the documents and more than just the assets. So I allow my clients to talk about their loved ones on a recorded video. We ask them questions and they explain how they want their children to be raised in case they're not able to raise them. They also explain what is important to them, share their values with their loved ones, and in most cases, my clients appreciate that more than the assets and the documents. They appreciate passing on that to their loved ones and they absolutely enjoy the process. In my opinion, leaving a legacy has a lot more to do than just documents and the money. It has a lot to do with just sharing a piece of yourself with your loved ones when you're gone. Something for them to look at, to listen to, and to remember you. And that's what we're focused on doing at my law firm. So if that's something that interests you, don't forget to actually schedule a free call with me. And I'm happy to talk with you about that and what's important to you. Thank you so much for watching this video today. If you like it, please share it with your friends and family. Don't forget to like and subscribe as well. See you on the next video.